Good evening. Aloha. Welcome to another edition of HCCLA's Reasonable Doubt. It's the luau episode. There's supposed to be like sound in the background. We didn't make that work. I've got with me tonight HCCLA President and lawyer extraordinaire, Brent Mayr.
Good evening,
thanks.
And mahalo, I
Mahalo.
guess.
That's welcome, right?
Right.
Mahalo. Yeah, I was like,
yes.
Aloha and welcome. Yeah, I botched that. We just came from the luau, our annual fun summer party, right?
Yeah, so I guess tonight's episode is really geared to the people who couldn't show up to the luau this evening. It was a well-attended event. We had a number of members there. We had a number of judicial candidates. We had a number of several members of our current judiciary. But yeah, tonight's episode is really for the people who couldn't make it to the luau and are still interested in hearing about criminal law issues here in Harris County, as well as, and it's really for people to watch on Facebook tomorrow.
Yeah. Yep. People who are at the luau tonight.
We don't expect you to be watching.
Yeah, when we left, it's 8. When we left, it was like bumping. It was a well-attended event. Our executive director, Christina Appelt, just like knocked it out of the park again.
Yeah, I think it's exciting that this organization is really moving in a positive direction in a number of ways to really make its mark here on the criminal justice system here in Harris County. So, but obviously there's a lot that's going on that we probably need to talk about today.
Yeah,
so.
yeah. You had mentioned the judicial candidates, and I saw, it was like last week or the week before, I got a phone call. I was like one of those people who got the poll call, and I got to answer questions about what I thought was going on in Harris County and local officials, and I saw today like some of those results started to come out.
Yeah.
We were talking about before the show started.
So I think it's always worth mentioning to the general public. We as lawyers, we know that Lena Hidalgo, even though she is the county judge, is not an actual judicial officer. She doesn't actually sit over in a court of law, and I think it's important for people to remember that. But I think
she's not a judge. Ed Emmett's come on the show before, and he would make it clear. It's funny, I'm not a judge and I don't work in a courtroom, but I'm the county judge.
That's right. But we still have, and it's funny, and I think it's important that the public know that we have a number of judges that are going to be coming up for election here pretty soon in this next election cycle, and with redistricting and everything that's going on, it's going to be interesting to see what's going to take place over the next 6 months leading up to the primary elections, which will be next spring, and then eventually going into the midterm elections in November of 2026.
Yeah, that's
Crazy.
Right. It's that far away.
Well,
but it's also real close.
Really close.
Yeah.
It feels like it's going to be close. So I think I think it's first of all what we need. I think it's important for the public to know about is. These judicial races don't get a lot of attention. Right. And but who the people elect to the bench and to the judge as elected as judges, they impact so many people's lives. They affect us as practitioners. They affect prosecutors. They affect how crime victims are viewed. They affect how defendants are, how their rights are enforced. So I really, as president of HCCLA, even though we are a non-partisan and non-political organization, we're still very, I think it's safe to say that we want the public to be informed.
Absolutely.
As to some of the judicial candidates that are out there and what's happening and what to expect, leading into this next year, which is going to be interesting with redistricting going on.
Yeah, who's going to come out and vote is going to be a really big question. And the HCCLA uses reasonable doubt whenever we can to invite current judges, other local officials, and then candidates to come on. So I expect we'll probably have another round of candidate forums again on the show. You think?
Yeah, we were talking about inviting some candidates to come out to.
That's right, episode. From the luau.
From the luau.
I realized maybe it would be a little bit less of an inhibited show too early in their campaigns.
True. But the idea is that again we want the general public to be able to learn about these candidates, to learn about these judges and what's really happening, rather than just hearing the spin that's coming out of Austin. I mean, a lot of what's happening with the changes in law, that are going to go into effect in September, a lot of it has been driven by what is perceived to be happening here in Harris County. I think it's important for the general public to know what's really happening, what's really going on. So, I mean, we could start with talking about bail. We can start talking about what these judges are doing with some of these decisions. Obviously, we had the recusal matter that came up last week, which I think will be something that we need to talk about in tonight's episode. And
yeah, the recusal that the Harris County District Attorney's Office filed against Judge Melissa Morris. In the motion for new trial proceeding after she presided over the entire trial. Tell us a little bit about that.
Yeah. So this all started with a fairly notable trial involving a defendant. I believe his name is Aaron Wright, charged with an aggravated assault with a deadly weapon of a family member. And, you know, he had been arrested back in 2021, released on a very, what I think is a pretty substantial bond, $175,000 in bond.
I don't have that kind of money.
Yeah, and a lot of people don't. And again, this is, you know, you hear all these stories about defendants, you know, getting out on these these low bonds and everything. I mean, this was a case of an individual who got out on a very significant bond, was placed under.
Do you know whether that person had criminal history?
I don't know if he. I don't know if he had any criminal history.
What's the Harris County standard bond amount on somebody on an aggravated assault with a deadly weapon of a family member as a first offense?
You know, again, you're seeing bonds, I think, anywhere from $25,000 up to $75,000. So they're pretty significant.
Standard bond amount, yeah, it's usually about 20 to 40 on the first offense for that kind of second or first degree felony. 175,000 is much more than that.
Oh yeah, and then I think what the public needs to know also is not only is a person like this individual having to put up a substantial amount of money to be released while they're awaiting trial, they're being placed under some very strict bond conditions. I know this particular defendant, I believe he was on an ankle monitor with home confinement. He could only leave for very limited purposes. And so you had some very strong conditions that were put in place. And for 4 years, he complied with those conditions before he actually had an opportunity for his case to go to trial.
So his day in court.
Right, have his day in court. And he had his day in court, but during the trial, the allegation that was made after the trial took place is that the prosecutors engaged in some what would be considered to be misconduct, engaging in some illegal arguments that are not permissible under the law. And he was nevertheless convicted and sentenced to 50 years, but hired a really good local attorney, Stanley Schneider, who's past ACCLA president, TCDLA Hall of Fame, to file a motion for new trial, asking the judge to set aside that verdict because of all the problems that occurred with the prosecutor's presentation of their case and the fact that they had made improper arguments in closing argument. And the long short of it was...
Well, hold on, because we have, I was going to look over to your camera, we have a big brain, but tell them what a motion for new trial is and how that works timing-wise.
Perfect. Yeah, that's good. So,
'cause that's in play here.
Right, absolutely. Yeah. So when you have a trial and there is a conviction, but there's some mistake that was made during the course of the trial. It could have been a mistake with a judge's ruling. It could have been a mistake with something that the jurors did, some improper conduct with the jurors, for instance. If a juror goes out on their own and independently investigates something and learns something that they're not supposed to know or is false.
Consider something that's not evidence presented at trial.
Right after someone is found guilty, there is a period of time, a very limited period of time, 30 days, when a defendant can go back to the judge and say, Judge...
The same judge that just handed down the conviction.
The same judge who presided over the trial the same judge that, made the rulings, heard the evidence in the case, received the verdict. Sometimes in those 30 days afterwards, the parties learn of something that went very wrong with the trial. And they have an opportunity to go back to the judge and say, Judge, here is a very serious problem that occurred during this trial. We want you, judge, who just tried over this case, to hit the reset button, to give us an opportunity to correct this miscarriage of justice, this trial that even though it was a trial, the argument is basically that it was a poisoned trial.
Right.
That there was something that infected this trial being a fair and impartial proceeding that rendered justice, that resulted in a just verdict. And so you go back to the judge and you say, Judge, here are the reasons why. Now, ordinarily, these don't get granted very often because it's hard within that 30-day period to find certain things. But in this particular case,
and this is not an appeal.
It's not an appeal. It's like an appeal, right?
An appeal goes to a different judge and says, look at what the other judge did. They made mistakes. Fix that or change it or give me a new trial because of those mistakes. This is going back to the same judge where the court happened and saying, I found something out.
And that's what the general public knows an appeal about, right? Is a defendant is convicted and they give a notice of an appeal. They say, we're going to appeal the decision. It goes up to a different court that is going to review everything that took place in the trial. And they're going to decide whether, okay, we're going to reverse the trial and we're going to grant a new trial. We saw that. We've seen that in several cases. Susan Wright got a new trial in her case. She was the woman who stabbed her husband multiple times. But the motion for new trial is a sort of a step before you get to an appeal.
Right.
Before we leave the trial court and we go up to the Court of Appeals to have them review everything, it gives a defendant an opportunity to go before the judge and say, Judge, before this case goes up on appeal, we need to make you aware of this, and for these reasons, we think that you should grant a new trial. And for hundreds of years, judges all over the state of Texas have had this authority, and even in federal court, judges have this authority before the case goes up on appeal to say, to look at what has taken place and realize, wait a second, this trial that we just finished last week or 2 weeks ago or a month ago, something went terribly wrong. And for these reasons, rather than waste the appeals court's time and waste 1 year, 2 years for an appellate court to make a decision, the judge has that discretion to say, let's just hit the reset button and let's do it again, and let's do it again right this time.
Right.
I think that's the main thing that people need to understand in the Wright case is that it wasn't like he was just being let go and free and that's
Right.
it. He's free to walk away and live the rest of his life. I mean, he still has to go back and go through the same trial process. Mm-hmm. But the idea is to we didn't do it right the first time. So let's right now, because that's the other thing too, is once the new trial is granted, you could have a new trial within a month or 2 months or 3 months. You could have it done very quickly.
The appeal, like you said, takes years. Last motion for new trial I had granted, it was in a misdemeanor DWI case. And the jury convicted my client, which is why you have to do that, and nobody understood why. The judge, the prosecutor, me, my client, everyone was like, that's a not guilty all day long. In fact, the chief didn't even stick around for the verdict because she was like, she told the three, this is back when they were 2s and 3s and the 3 tried the case, like just text me when the jury says not guilty. And when we found out it was a guilty, we were flabbergasted. So the next morning, the chief and I were in the back hallway just kind of debriefing, trying to figure out why they convicted. And we talked to the jury afterwards. We had no, the jury didn't want to talk to us afterwards. And the bailiff went by, just walked by us, he's drinking his cup of coffee, and he's like, this is even like before docket really started. It's like 8:45 or so in the morning. He walks by with his cup of coffee, and he's like, oh, y'all talking about the trial from yesterday? We're like, yeah. We're like, we don't understand how they convicted. And he's like, oh, because your client was black. And I was like, what? And the chief I was talking to was black too. And she laughed, and he was like, no, I'm serious. Like, they had me escort them to their car because they were afraid of your client. And I was like, this is a DWI case. My client has no criminal history, and he's a cardiologist. Now, he has very dark skin. His family is from Jamaica. And I had to go and tell my client that.
Oh, man.
It broke his heart. He's like, he wore the nicest suits in court because he's like, I never get to wear my suits. I wear scrubs every day. I'm in surgery 2 weeks of every month, and I'm in the office. Other times, I got to wear my nice suits. We were like, how did the jury ever come up with this? No idea. But the judge, get me a motion for new trial. I'll grant it right then.
Yeah.
The DA's office then put him on a 6-week PTI and dismissed the case.
Yeah, that's good. And I mean, that's
the kind of thing, right?
That is exactly what the motion for new trial.
No way we would have known that if they hadn't told the bailiff, can you escort us to our car?
Right.
And then he tells us.
And we want judges to be able to make those decisions, to recognize that something like that went terribly wrong, and say, look, rather than waste all this time and resource and money to have another group of judges spend a year or more reviewing this, let's just start over again.
Right.
And let's try it again. And if he's convicted, and he's convicted the right way without any of those problems, then he can appeal it and the court can review it. But anyway.
So what happened in Mr. Wright's case?
In Mr. Wright's case, Stan Schneider, representing, who takes over the case, looks at it and says, wait, there's some serious problems in this case. Talks with the lawyer. The lawyer who tried the case acknowledges that there were problems with the case. They present all of this to Judge Morris, Melissa Morris, presiding judge of the 263rd, a very fair and impartial judge. And after she hears all of the evidence, basically tells the parties, look, she doesn't say explicitly, but it's pretty understood that she's going to, in all likelihood, grant a new trial, and she wants the parties to help prepare the reasons to support her ruling, which, again, is very common in courts all over the state, right? Judges will ask the parties to say, hey, help prepare what I need to justify my ruling. And when that happens...
Sorry about the train.
That's okay.
It's a live show.
That happens. Hello, train. So, essentially, what ends up happening is they go and the DA's office sees what's about to happen, and they go and they file a motion to recuse the judge.
Sorry.
So, okay.
I'm laughing because you're talking louder and get off the tracks.
The show is
so
not
the DA's, going. Yeah, okay, the horn was, but the DA's office filed a motion to recuse?
A motion to recuse.
The judge that they were okay with trying the case in the first place?
And again, that's what's, and the judge that they've tried cases in front of since she took the bench over 2 years ago.
Right.
Or more than 4 years ago almost. They've tried all these cases. There's been multiple domestic violence cases where she's handed down significant sentences involving an incarceration. But all of a sudden, they're now going to say, we think the judge is so biased, is so biased against us and has done something so improper that we need to have her removed from the case.
Well, wasn't bias against the state, was it?
That was what their allegation was, is that they were alleging two things, that she was biased against them, but then they also threw in this bias towards victims of domestic violence.
That's what I had heard. And
that's what our organization took some issue with, because, for a judge, again, Judge Morris had sentenced hundreds of individuals who were convicted, who had pled guilty or who were convicted of domestic violence cases, had sentenced hundreds of them to incarceration. Mm-hmm. And so now for them to allege that she had some bias against some victims, the problem in this case is that she had some questions about the alleged victim in that particular case. Mm-hmm. But that's what judges are for, right? The judges are like a jury. They're sitting there, they're listening to the evidence. they're deciding what evidence is admissible, what's not admissible, but they're also given the discretion to make decisions about whether they believe a witness or they don't believe a witness. And in this particular case, Judge Morris has found, she's been involved in hundreds of cases where she's believed and found victims of domestic violence to be reliable and credible. But in this particular case, she just had some questions about this one, and that's where the DA's office took some issue and said that that meant some bias that required a recusal. And so...
And a recusal requires a bias that is, the judge has something against a party or the type of case that's so strong they cannot be neutral or objective, which they are required to do by their oath.
That's correct. The way that
it's pretty extreme.
It is extreme. There has to be, the way that the law breaks down, this is for the general public to know, is that there's really two ways. There's actual bias towards one of the litigants or one of the parties, but there's also a basis to remove the judge when anyone looking at how the judge is handling it, looking at how the judge is handling the case, would say that this judge is way biased towards one side or the other. And again, looking at this, the judge is making decisions, but she's not demonstrating any sort of bias. I mean, she's upset at the prosecutor because she kept making this, what she believed to be an improper argument, even though the judge sustained. It's kind of like in when we watch on television, right? The judge says sustain, but the lawyer keeps doing what they were, what drew the objection in the first place, and the judge is like, I sustained that objection, and the lawyer just kept going and going and going, and
that means change your question.
Change your questions. But look, just because a judge gets upset, and I mean that's what was so absurd about this motion. It's like, the DAs were like, the judge was making her they were complaining about her facial expressions, right?
I gotta admit, I didn't know I could complain about that. This makes me think of all the judges that I'm like, you don't think you've demonstrated a bias against a certain type of case or defendants in general? Could we start doing that and just recusing entire criminal courts because you seem biased against considering the minimums? We know there are district court judges right now, not just in Harris County, where they will not even entertain the minimum sentence. And prosecutors come at you with a 3-year sentence. You're like, no, how about 2? And they're like, judge won't do 2.
Yeah.
Like, what? The jurors aren't qualified if they won't consider the full range of punishment, but the judge gets to preside when they won't consider the minimum?
Right.
So, sorry, side note. Back to this actual issue here.
Yeah, like I said, judges can get upset with the lawyers. The judges can find that a witness is not believable.
They can be biased, but you have to hear the evidence first. I tell my clients all the time, the jury can be biased against you, but not till they've heard all the evidence and they go deliberate.
Right. And in this particular case, that's what happened. Is Judge Morris was making decisions based on what she was hearing in the courtroom.
Yeah.
It wasn't like your trial, Justin, where the jurors, were just making their decision based on the fact of just based on the color of his skin.
Really dark black.
Right.
Yeah.
Right. So the DA's office files a motion to recuse, and this is where things get interesting. And again, the public never knows anything about this and how it works. But here's what's interesting, and here's how it affects defendants and citizens and everyone else. Once any party, whether it's the defendant or the state, files a motion to recuse, it stops everything. So even though the judge is leaning towards granting a new trial, the DAs, not during the trial, not immediately after the trial, they wait until after the hearing where the writing is on the wall and they think that they're going to lose this motion, that appears to be a preemptive move says, let's file the motion to recuse and let's stop the judge from making a decision.
So you say it's after the hearing. So this is something we see a lot, right? We have a hearing on whatever the issue is, and the judge will say, come back tomorrow and I'll give you my ruling. Or sometimes even give me 30 minutes and I'll come back and issue my ruling. And so you're saying between those two times, the DA's office files this recusal that just makes her have to like let go of the whole thing?
At that point, the judge has two options and two options only. The judge can recognize that, you know what, I'm not equipped to make this decision because of a bias or prejudice or a connection that I have to the parties. And the judge can say, okay, I am going to recuse myself and let another judge take over and make a decision.
The judge can say, you're right, I should be removed.
If the judge disagrees with this is the difference between federal court and state court. In federal court, the judge just decides whether they're
like, no, I'm not biased.
I'm not biased. But in state court, what we have here in Texas, and again, this has been the law for a long time, is it gets referred to an administrative judge who is going to review everything, sort of be the outside observer. We think of it like when you appeal a decision during a baseball game and they send the call to New York, right?
Right.
They're sending it to another group of individuals. Well, the same thing happens here, is Judge Morris can't make the decision because she's part of what's being alleged, and so it gets referred to an administrative judge. In this case, our administrative judge here in Harris County, the Honorable Susan Brown, gets it. Now, she doesn't realize the short amount of time that this decision has to be made in. Remember, like I said, this is only within that 30-day window before you have to go up on appeal. So at first she schedules a hearing, but Mr. Schneider says, Judge, we need to have a hearing sooner. And so on the very last day that a motion for new trial can be granted, she schedules a hearing, and she hears evidence from the prosecutors who come in and basically make their case and talk about what took place during the trial. And they hear all this evidence, and Judge Brown, being a very experienced, very knowledgeable judge, and a very wise judge, made the right call in this case. Said, no, the judge is not going to be recused. This is the judge doing what a judge is supposed to do, make decisions about what's taking place in the courtroom. And the judge denied, now she didn't make any, in her defense, she didn't give any reasons for her ruling, but the law and the facts just were not there. She denies the motion, and then ultimately Judge Morris granted the motion for new trial. And so, you know, at the end of the day, the right result occurred. Now, the state gets to appeal the decision to grant a new trial, and so that issue will be reviewed. And if the Court of Appeals decides that a motion for a new trial should not have been granted, well, then the conviction's going to stand, the sentence is going to stand, and the defendant's going to get his own right to appeal his conviction and what took place in the trial. So,
has the District Attorney's Office for Harris County indicated they are going to appeal the granting?
They have, within days of Judge Morris granting the new trial to Mr. Wright. The DA's office filed their notice of appeal, and the case is currently before the Court of Appeals.
This is just a nerdy legal question. Could they appeal the Judge Brown's denial of the recusal?
That's a really good question. So it appears...
Not that they should. Don't get any ideas.
Well, no. I mean, from what I understand, that is part of their appeal, but the rules don't explicitly state that is something that can be taken up on appeal. So that's going to be another interesting issue in itself. Here's what the general public needs to know about this, though. We want to believe in our judges as being fair and impartial. I mean, across our board, we've got good judges here in Harris County. I mean, are there some judges that we sometimes complain about a little bit more than others? Yeah. But that's how it's been for hundreds of years, right? There's going to be some judges that are liked more by the state. There's going to be some judges that are liked more by the defense. There's going to be some judges that are viewed favorably by both parties. There's some judges that are not favorable like. That's just how it happens, right? But for our judicial system to work, we can't have it where anytime you don't like a judge's ruling, you can just say, well, I just want to get rid of the judge.
It's because you're biased.
Because you're biased.
Yeah.
And, I mean, we see this happening on a national level, right?
I was thinking the same thing.
We see this happen on a national level. And that's what was so redeeming about Judge Brown denying the motion to recuse and allowing Judge Morris to make what she believed is the right decision in this case. That's the way that our legal system needs to function. We need to let our judges make decisions based on the facts and circumstances available to them at the time to do what is right based on the law and based on the facts, right? If a party doesn't like it, they can appeal that decision. But we don't want to have people convicted for the wrong reasons. We all know what happens when people are convicted for the wrong reasons, when people are convicted not according to the law, when people are convicted in a way where their rights are being violated. We want to give judges the ability to say, this person needs to be granted a new trial. This person needs to be granted a reasonable bond. And it's nice to see things kind of drifting back in that direction, and that we have Judge Brown willing to come in and say, no, I'm not going to, because you have to understand, Judge Brown has recused some other judges in Harris County in other cases with a very specific set of facts where she says there might be a question here, right? But in this particular case, it was really a situation where the DAs were not happy with the ruling that was coming and tried to stop that by saying, well, let's just get a new judge. And for Judge Brown to come in and say, I'm not going to allow this recusal to, I'm not going to recuse Judge Morris. It really upholds the value that we need to have for our criminal justice system, for our legal system to work, which is that, look, just because a judge doesn't rule in your favor doesn't mean that you can just get rid of the judge or remove the judge.
I agree with that, but there was also a little bit, I mean, correct me if I'm wrong, we don't know what was going on in their minds. Prosecutors like to tell us what was going on in our clients' minds when they're doing the things they're accused of, so I don't want to necessarily fall into that same trap. But there was a little bit of an element of kind of like gamesmanship here, right? Because this was filed in the 11th hour for the judge to issue the ruling.
Yeah.
So that whole hands-off thing, I think some people kind of thought, this is what I sort of heard around the courthouse, was that the thought would be that in that time where Judge Morris can't touch it, and now nobody can touch it until the recusal gets heard, and then the clock runs out on the motion for new trial. And then when the recusal gets denied because it's frivolous, it just happens to be too late for anybody to grant that motion for new trial. Yeah. Because from what I understand, that hearing for Judge Morris to be recused was conducted by Judge Brown at like 3 o'clock in the afternoon. And she had to rule on that. And then before midnight that night, midnight that night was the deadline to rule on the hearing that Judge Morris had already conducted on the motion for new trial. Right. So it felt a little bit like not just the DA saying we're trying to seek justice the best way possible, but also kind of like this will make the clock just run out. Yeah, I don't like that. Yeah, and I think you're right to not like that, right? I mean, we don't want our prosecutors who we trust to seek justice engaging in sort of a gamemanship to again, just because they don't like a judge's ruling or just because they don't like a jury's verdict, that they're doing something to prevent that from happening. I will say this. I'm glad that everything turned out the way that it did, because I feel after that experience, and so that the public knows, again, we had a tremendous turnout for this hearing. You know, the defense bar. The defense bar. I didn't get to make it. How full was the courtroom?
Look, even if you did make it, there was no room. I had flown in from Del Rio, had landed, jumped in my car, went straight to the courthouse, made it there just in time for the closing arguments, and I literally had to sit like with my legs crossed on the floor until a seat became available. It was packed, and it was tremendous to see I mean, again, this is 3 o'clock in the afternoon. These recusal hearings rarely happen. When they do, there might be 5 or 6 lawyers there. The fact that we had it packed with defense attorneys was incredible. But that showing, and with Judge Brown making the right ruling in this case to not allow Judge Morris to be recused under these circumstances, I have some faith that the Harris County District Attorney's Office is not going to file these motions on a regular basis. I think we as a defense bar, we need to be prepared, right? We need to be prepared, but at the same time, it's just not good for our justice system. It's not good for our legal system. Again, when parties are complaining and saying, I want a different judge because this judge is not ruling in my favor.
Right.
And, I think that's sort of it's a nice segue to talking about just sort of the political influence that we're starting to see on our judicial races. Come September, we're going to see a lot of new laws go into effect that have been put into place because of the perception, the spin that the legislators in Austin are putting on what our judges are doing here in Harris County. The general public needs to know that our judges are doing the right thing. They are following the law. They are protecting defendants' rights. But at the same time, when there's a danger to the community and they're presented with evidence of a danger to the community, they're setting high bonds. They're putting some onerous conditions on defendants. And I don't think that message is being amplified enough throughout the state, and that's what's allowing these laws to come in where they're trying to take away a lot of this discretion from the judges.
Taking away, and the discretion that they're taking away is by removing certain things from our Constitution, and which are where our rights are protected.
Right.
There is a constitutional amendment that's coming up, right, that has to do with bail and changing the Constitution and bail equals freedom. So when you vote against bail and you want to reduce and reform bail to have less of it, you're literally saying, I want to restrict freedom. I want there to be less freedom out there. That's what that is.
And look, it's amazing because bail has become like this bad word, and bail. What bail? Bail? What the people don't understand is, Donald Trump was released on bail after he was accused of a crime that he was ultimately
convicted of, many crimes.
Well, or dismissed. You think about all the people that were arrested, all the politicians that were arrested and charged in that investigation, they were released on bail, right? Why is that? Because every single one of us are presumed innocent when we're accused of a crime.
Right.
There's this idea that, just because on the news they're reporting that this person killed this person, or this person assaulted this person, or this person was drinking and driving and caused this, the people think, well, they're guilty, why should they get released? And it does not work that way.
Right.
And I wish that message would get amplified to the general public so that they would understand that we need to have bail. Okay?
Right.
We need to have bail so that any one of us, any one of you watching, all of a sudden find yourself accused of a crime and you're like, what do you mean I'm accused of a crime?
Right.
You're still presumed innocent, and because you're presumed innocent, you're entitled to bond. There's a Supreme Court decision that I love to cite to that talks about, from like the 1800s, that talks about that the right to this presumption of innocence that our forefathers fought to obtain, would lose all meaning if we just said we're going to hold people without bail,
right,
while they're waiting for months or years to go to trial. And if that message can get out to the public and really can get up to Austin, I think that we're not going to see this effort to try to strip away people's rights and again, to castigate and treat bail as some bad word, as this is horrible that we have bail. We need to have bail in this country. Everyone, every single person watching, driving around thinking, I'll never find myself in that position. Guess what?
I got a lot of clients. A lot of clients.
Preach, brother. Preach.
Yeah.
Tell about it.
Yeah, it's always one way until it's you, right? Even a client that I was in trial with, we were talking about what the law allows under 3823, and he was like, that is crazy. Now, I used an example that was a little bit ludicrous about someone breaks into a home and stumbles over a dead body, that may not be admissible at court because they burglarized that house. But I reassured him that doesn't really something that anybody needs to lose sleep or worry about actually happening. But yeah, bail is a fundamental right. And not only is it, this thing that I think people like us care about as a presumption of innocence, this thing that you can't touch and you can talk about, but it's also extremely real. When you're locked up, getting ready for trial, defending yourself is much harder to do than like just being able to pick up the phone and call your lawyer and ask a question, or your lawyer pick up the phone and call you and be like, I'm watching this thing. What is this word you say? I can't hear it quite right. Or they go around the corner. What do you guys do over there? You know, you got to go see somebody who's in jail. I mean, I think the conviction rate would go up a whole lot for a variety of reasons, but not the least of which would be it's hard to help your attorney. It's hard to get help from your client when they're locked away.
Yeah. I mean,
now in Harris County, they're shipping them out of state. I got clients we set for trial next week, and they're out of state.
Look at the P. Diddy situation, right?
Right.
There's a situation where he was denied bail, right? Because there was this fear that he was going to intimidate witnesses and tamper with witnesses and flee the country because of all of his resources. And look what happens in his case. He goes to trial. He's acquitted of the serious charges
Stuff
against
that would
him.
keep him in there, yeah.
Right. But that whole time, of preparing for trial, his lawyers had to travel out to the federal detention center to meet with him and prepare for him. And when you have, look how long that trial took, right? So can you imagine how much evidence was in that case? And how do you
There's no way he got to see it all.
There's no way he
has a legal constitutional right to see the evidence that they have against him before trial, and there's just no way. Like the sheriff won't even let you bring it all in a lot of times. So,
but look, even that case, polarizing case. Look, Ken Paxton, okay, our attorney general was accused of a crime. He was indicted for a felony offense. He got released on bail.
Yeah.
They
and he should have, whether you like him or don't like him, he should have been able to be out on bail, follow rules that just make sure he comes to court and the community's safe from our attorney general, and let him fight his case. And then what happened with that case?
And he ends up,
it's dismissed.
It ends up getting dismissed.
And if we had left him locked up, would he have had to pay the bill for the sheriff's office?
No.
No. And if you look at, we talked about this on the show about a month ago, if you look at the budget breakdown, the sheriff's, just the jail budget is 9 digits. It's over $100 million, if I remember correctly.
Right.
And the people who supervise folks who are out on bond, there's more people out on bond than in jail, right? People who supervise those folks, that budget's $30 million. It's still too high. The stuff that they're putting on people, the ankle monitors, all that stuff, it's too much.
Yeah.
But I'll tell clients all the time, I'd rather you have an ankle monitor and be at home than be here in the jail.
Oh yeah, absolutely. God, we could just go on. Former Governor Perry,
right.
He was indicted
That's true.
for a felony. He was released on bail. Again, the public needs to know that this bail is not some bad thing. And with all the elections that are going to be coming up, I'm sure we're going to hear about I'm not going to set bail and I'm not going to do that. The public needs to be concerned about the judges that want to deny bail to everyone, because what they are telling you, what they are saying, but without saying, is I don't care about defendants' rights. I don't care about the presumption of innocence. I don't care that even though bail is not to be used as an instrument of oppression, I'm going to use it to oppress you. I am going to take you, Ken Paxton, P. Diddy, any person who's accused of a crime, and we're going to say, we're going to lock you up even though you have not been found guilty. We don't care what happens to you later on, even if you're acquitted of multiple counts. We're gonna take you away. We're gonna punish you. We're gonna lock you up for a year, maybe longer, and
until you prove your innocence and get out.
It's got to scare the public.
It should.
It's got to scare the public. Now, look, are individuals now? Let's go. We were talking about the DA's office and what we're hoping for the DA's office, right? We're hoping that the DA's office is not going to be filing these motions to recuse. Let's hope that the DAs will not abuse these laws, but will actually enforce them, right? These new laws are going to make it where if they can present credible evidence, right, that someone is going to keep committing crimes if you release them on bail, then the law is going to allow them to do that. That's how it works in federal court. But in federal court, the judges want to see good, credible evidence, not just speculation and not just,
they did it before.
They've done it before, right? Bring in, I think in federal court where, they bring in text messages where a person is saying, I need to get rid of my property so I can flee the country. That's good, reliable evidence that, okay, that's going to justify a judge saying, okay, I'm going to set a high bond or I'm going to deny someone bail. But I really hope that the DA's office is will bring good, credible evidence and won't just throw out these allegations without any sort of substance to them to justify holding people without bail.
It's the Uncle Ben rule, right? With great power comes great responsibility.
That's how it works.
Yeah. So talking about the DA's office, though, there's some changes that have been kind of going on over there. We had Sean on the show, Sean Tier. He had said that he was hoping to start recruiting some DAs from like moot court and mock trial competitions and other places.
Yeah.
I know they had baby DA school a couple weeks ago, so you don't come down below the 11th floor much, but the misdemeanor courts were like a ghost town. There were some felony prosecutors in there covering for chiefs and stuff. Nothing got done for a little while in some of the misdemeanor courts. It was frustrating a lot of the judges. But I went to some of I have felonies too, and I went to some district courts, and it's been kind of tighter ship around there.
Yeah, it's going to be, it's really going to be an interesting time over the next year leading up to the next election to see how our criminal justice system is going to function effectively, because we have judges that are trying to do the right thing and make good decisions that impact crime victims as well as defendants. But yeah, right now, the district attorney's office, they're short-staffed. I mean, they do not have, like you said, there's a number of courts where you go in and there's just not enough prosecutors to be doing the work. And, you know, it's commendable what Sean Tier and his staff and his administration are doing. I mean, he's got some great people in the upper levels.
Oh, absolutely.
But then there's just this big gap of people there's a big gap where there's no prosecutors, or there's prosecutors that have no experience, or they haven't received the full amount of training. They don't have all the knowledge and skill that people like Sean and Lauren Byrne and Amy Valentino and Catherine Evans and Angela Welton and Alicia Harvey and all these, and Katie Warren. There's all these good senior level prosecutors, but then there's this big gap with all these prosecutors that have to learn and experience. And, you know, Sean had talked about wanting to get more experience for these trials, for these new prosecutors, but it's tough.
Yeah.
They pulled in some prosecutors from other counties. I know that they've got like 30 new prosecutors coming right out of new hires that are coming right out of law school, which is good. But it's going to take time.
Time, right?
It's going to take time.
Well, and you know, the other thing I just thought of when I was sitting here is, you know, Sean and Lauren and Cheryl and everybody over there and Chandler, like, don't push them to trial quite yet. Because keep in mind, what's going to trial right now is stuff that was filed in intake under the previous administration. Yeah. So these aren't even pure Sean Tier administration cases. The trial I was in this week is the case that should not have been tried. It worked out the exact way that it did, but it should not have gone to trial. And it took experienced attorneys talking to a less experienced prosecutor to get them to see you are about to lose like the forest for the trees here.
Yeah.
Okay. And that is a case that charge should have been taken. Absolutely, the charge should have been taken. But more experience on working that out would have saved taxpayers a lot of money, me a lot of time. But that's what I'd like to see, is a little bit more like attention. There's been some changes in intake, right? We've heard numbers coming out of the DA's office that there is the lower jail numbers they are directly taking credit for. Saying there's fewer people in the Harris County Jail, the numbers are more reasonable because we're locking up the right people and we're taking the right charges. We'll see if that's really the case. But it'll take another 6 to 12 months for some of the cases that have been filed in the last 7 months to kind of ripen enough for a trial.
I think it's going to take longer than that, Justin.
Okay.
I mean, I was in the DA's office for 6 years. You know,
talk to us about that experience. You have a lot of inside track.
Right. I mean, so back when I was a prosecutor, you know, I had 30 trials before I became a felony prosecutor,
Right.
and then I had 30 more, and I gained a lot of experience from trying cases. I learned a lot. I spent a lot of time researching the law. We had good, experienced prosecutors that had been doing this for 20 years, Kelly Siegler, Lucy Davidson, Casey Garrett, that were coming down and training us. And again, the DA's office, they've got a good core, but it wasn't the same number that they had then. And again, there was positions were filled. And
what does that mean? Sorry, I'm cutting you off. I've heard this. I've never been a DA. When you say like you had Kelly Siegler and Casey Garrett and other ones coming down to train me.
Right.
What does that mean? How does that work?
So like,
I'll text you. I'll call you for like advice. Brent, what do I do with this? What do I do with that? And you'll tell me. I mean, is that what DAs do?
It's kind of like that, but then just like our organization sponsors and puts on continuing legal education events to train lawyers how to pick a jury and how to give a compelling opening statement and how to cross-examine. They were doing that in-house is what they were doing.
Okay.
And then...
So you get all the baby prosecutors together and they'd say, Kelly Siegler is going to teach you how to do a closing argument like a champ.
But over the past 10, 15 years, the talent started leaving or getting fired with changes in administration. And so now it's not so easy to do things like that, right? A lot of, I think it was back in Ogg's administration, or maybe it was Likas's administration, where, they were just farming out all of that training to organizations like the Texas District and County Attorneys Association. But I think if they can return to that, it's cheaper, it's more efficient, right? You don't have to take time off, you don't have to pay for travel expenses. You do it in-house one afternoon, and I think that would, there's a lot to be learned from that. But again,
did y'all have like HCCLA? Sorry, did the DA's office have like brainstorming sessions like HCCLA, like one day a month? We'll get together and just open floor for all defense attorneys to get together and just spitball about ideas.
We never had anything like that, and I'm not aware of anything that's that's happened any time in the past 10 years within the DA's office. Granted, I don't know I don't know the inner workings that well anymore.
What about, we have like a second chair program through HCCLA where you can be mentored, matched up. I know you have a chief situation.
Right.
Who you could sit here right now and you could talk about your chiefs in like a doting, admirable way. So y'all have that kind of mentor relationship, but do y'all pair up with?
Well, again, that's what we had back in my days years ago when we had a fully staffed office. Even though I had a chief, Lucy Davidson was my second chair, and I had a murder case, and she came and she helped me work the murder case up, and she tried the murder case with me, and she told me to plead the case out when I should have, and I said, no, I'm going to win this trial, and I ended up losing. But again, we had those types of things. Now, but trying to put these things into effect in the DA's office when there's so many missing people, right? There's just not enough lawyers. It's going to be hard, and I think the public needs to understand it's going to be a chaotic time really over the next 6 months to a year, because you've got all these new laws that are coming to effect September 1 that are going to change, and it's going to, in many ways, make it more onerous for the prosecutors. They're going to have to have these hearings where they're going to have to present evidence to show the judge we need to deny bail because this person's a danger to the community. The district court judges are going to have to make more bail decisions because the magistrates can't work that.
Right.
There's a big backlog of individuals in the jail right now. I know that there's over 3,000 individuals that are incarcerated, just charged with low-level felonies that are just piling up.
Right.
There's a lot of work to be done by the DA's office, and they just don't have enough people to do it. And so it's going to take time for them to fill those positions, train those people, get them experience, and it's not going to happen overnight. So you
think that, are you like warning the viewers and the voters that it's going to be, when the chaos you're kind of foreshadowing, like, is it dangerous chaos, or is it just going to be like, we're going to be busier, grinding, and do the judges need to plan to stick around later than 11:30, some of them?
Possibly. No, I don't think it's so much that the public needs to be concerned about it. They've elected in my opinion, what is a good district attorney, and he's got some good leadership in place. It's just patience is what the public is going to have, and unfortunately, that's a hard thing to ask sometimes of people, especially of crime victims, of people who are being affected by crime,
and politicians.
Yeah, it's going to take time, but I think if the public is patient, and they have faith that there's good defense lawyers that are making sure that defendants' rights aren't trampled and judges aren't removed just because they don't like a ruling. I think that we're going to get to a good. I hope, and I think that we'll get to a good place. But again, it's going to take time and patience.
Yeah, well, you're not wrong there. So let's see. We got about a minute left. We covered a lot of our topics. We didn't get into the recent statistics about the deaths in the Harris County Jail.
Yeah.
We can spend quite a bit of time on that. And maybe we should. Maybe we should try to talk to some folks and see if they want to come on and have a more robust conversation about that. It deserves it.
We talked about bail, right? And one of the things that I know the ACLU tried to do is highlight some stories of individuals who spent months locked up behind bars before the DAs realized, oh, we got the wrong person, right. We're setting you free. And by that point, people have lost their jobs, they've lost their families, they've lost their reputations, they've lost income. I think the public needs to hear those stories. So yeah, that would be great to hear those stories.
We've had some folks on who've had those experiences. We need to do that again. You're right.
Yeah.
We've got about 30 seconds left. You want to take us out here?
Yeah, like I said, let's just encourage the public to just keep your ears open and don't just don't just buy into what is being promoted in sound bites coming out of Austin. Take the time to look and see what is happening in the courts. Come down and watch what's happening in the courts. Come see that these judges that the legislators in Austin are complaining about, they're making good decisions. They care about crime victims. They care about defendants' rights. I just want people to stay tuned.
Yeah, and you'll see it here on Reasonable Doubt whenever we're talking about it. Brent, Mr. President, thank you very much.
Thank you very much.
Appreciate it. And on behalf of Houston Media Source, Harris County Criminal Lawyers Association, we appreciate you all watching, and we'll see you all in 2 weeks. Thank you.